particular on the field of study of school finance. Obviously, it's got great impacts on the policy and on legal doctrine. But in terms of the impact on the study of school finance, I have to say I've actually been kind of surprised at how extensive it has been going back 40 years. It's really been quite extraordinary. You'll see it, for example, if you pick up any of the school finance textbooks, standard school finance policy textbooks, for example, by Professors Odden and Pikus. A couple of names that are familiar here in Arkansas because of their role here, but not just them. Textbook by Jim Guthrie, who we also had here earlier in this series. It's really quite striking how the role of the courts and the changing role of the courts has influenced, for better or for worse, and I'm going to say some ways it's influenced for the better, the study of school finance. You also see it, for example, one of the main professional organizations to which I belong, the American Education Finance Association. I had never been to their meetings before I returned to academia in 2006, and I was stunned, really, the extent to which the school finance litigation is a significant fact. Gary goes back a lot further than me in this, so he's seen it a longer time. They actually have workshops at the beginning of before the whole paper presenting part of the conference gets underway. The workshops with litigators, typically plaintiff litigators, and potential academics who might be interested in the. You actually pay extra for those workshops. I never have done that, but and academic conferences on this whole area. That's actually where I met Al, was at a conference at Harvard on the impact of school finance litigation. The impact, so some of the examples of the impact have been the development of statistical measures of equity, okay, started back in the 70s. More recently, attempts to develop methodologies with regard to costing out or determining the cost of school of adequacy have come into play, and this reflects the changes in the litigation strategies that have taken place over the decades. So I think the impact has been primarily, until relatively recently, from the plaintiff's side. It's now become, I think, more of a vibrant scholarly debate, and a couple of positive impacts. It has really shown up in heightened true interdisciplinary activity, legal, economics. You can see it in the co-authorship of the book that Al's peddling here, and that I've assigned to my students, along with the corresponding book from the other side of the debate. You see it also, here's an interesting angle, is you see it in the discovery process. In the discovery process in litigation, you can actually get the data from the other side and replicate their analysis, which is not always easy to do in the academic give and take. Anyway, I'm going on too long, but just to indicate a few dimensions of the impact on the field. Now, we're very fortunate to have with us today a major player from the last couple of decades of school finance litigation, and that includes both in the courtroom and, equally as important, as outside the courtroom in the negotiating process that takes place with the legislative and executive leaders of these states. Al is a native of North Dakota, small town near the Canadian border. You're north or south?
South.
South, okay.
Long ways.
Yeah, he said he was actually closer to Winnipeg than he was to Fargo, never mind to South Dakota. Graduating class, what did you say, was 13?
Yep.
Graduating class of 13, and then he went on to West Point, another military man here. And as your bio indicates, he was a highly decorated veteran of the Vietnam War in the Army Rangers, and commanded paratroop units during that war, which helps explain why he named his boat Soft Landing. He then, in return to civilian life, went to Harvard Law School and joined the law firm of Sutherland, Asbill, and Brennan in Atlanta, where he has had this distinguished career. He is now out of the courtroom and actually more in the classroom, in the seminar room. In fact, his counterpart on the other side of a lot of these court cases. Mike Rebell has invited him up to talk to his classroom at Columbia, and it has given him a chance to reflect a bit more on the meaning of a lot of this school finance litigation, and co-authored this book with Hanashek, which I've assigned along with the book by Rebell as well. So, Al Lindseth.
Well, thank you, Bob, for that kind introduction. Dr. Costrell, distinguished faculty, ladies and gentlemen. During my legal career, I have had the privilege of participating in many of these cases, including some of the largest. And they're interesting, they're controversial, they're complex, they're important when it comes to public policy. And for 30 years, I got to be part of that. And then after that, I got to do what every lawyer secretly wants to do, write a book about their experiences and stories. You know, as I was leaving yesterday, I was packing my blue pinstripe suit. My wife looks at me and says, "Wait a minute, you're not going to wear that, are you?" I said, "Well, yeah." She said, "No, you look too much like a lawyer. You're a scholar now. You got to dress like a scholar." So hence the tweed jacket. So, but seriously, what I'm going to do today is I'm going to try to take off my lawyer's hat in part and put on my scholar's hat, step back from the rough and tumble of the litigation, and share my what lessons I've drawn from 30 years of this. And over the course of the lecture, hopefully shed some light on the answer to this question, whether court intrusion into school finance decisions, and there I'm talking mainly about adequacy cases, have been a boon or a hindrance to education reform. You know, I think that school finance is one of the least understood aspects of government and education in this country. A number of years ago, I was privileged to represent the state of New York in a case involving school finance in the city of New York. And the plaintiffs in that case argued there was only one person in the entire state, an elderly lady in the state education department, who understood the mechanisms and formulas under which education money was distributed in New York City. And you know, they were right. And the public, the general public, I think, only has a clue. Surveys have shown that the majority think, well, education, there should be more money put into education. Teachers are underpaid. But what do they really know about education finance? Well, some researchers from Harvard University recently undertook to answer this question. Some of you may have read their article in Education Next. But I think their remarks or their findings are kind of interesting. And let me just show you. One of the questions they asked is, based on your best guess, what is the average amount of money spent each year for a child in public schools in your school district? And they included a prompt about what expenses this would entail. And the answer was $5,262 a pupil a year. Well, in actuality, in those school districts, they were spending over $10,000, almost twice as much. Now, what's remarkable about this slide, it doesn't show that half of the people thought they were spending in the range of $1,000 per pupil. 1/10 of what they were actually spending. On teacher salaries, the information was, I thought, very interesting too. They thought teachers were paying about $33,000 a year in their state. In actuality, the average was more like $47,000, 40 to 50% more. So I think that I show these figures because I think that the role of courts in school finance, there's a similar thing. Very few people know much about that. They know what they read in the newspaper, that there are schools that are in poor condition, children are not doing well, and that unless the court orders the legislature to raise funding, you know, everything is going to go to hell in a handbasket. But there's not much beyond that usually in the newspapers. The state, whatever their position is, frankly has a tough time getting its act together and are not very well, do not do well at dealing with the media. Now, the role of the courts in education finance has changed over the years. Prior to 1954, the courts played virtually no role. But that all changed dramatically with the famous decision in Brown v. Board of Education, which outlawed segregation in the schools. And after that case was filed, there were hundreds of cases filed in the federal courts all over the country. And some of these cases involved school finance. One of the most famous was in Kansas City, where the federal courts ordered massive spending increase. The budget of the district literally tripled in just a few years, funded by both the state of Missouri and by local property tax hikes. Now, beginning in the early 70s, or the late 60s, the state courts got into the act. Prior to this, they hadn't really been involved. And there were a number of suits filed in many states that demanded a more equal distribution of money among or between school districts. School districts then, as they still are to an extent, financed by local property taxes, mainly. And if you were blessed to live in an area with a lot of wealth, the schools could spend more money, often at a lower tax rate than the poor districts. And these suits were brought to remedy that situation. And they were brought in a lot of states, but whether they were actually filed or not, they had an impact because the legislature responded to these either because of the threat of a lawsuit or because of an order in a lawsuit. And there were many things that happened that equalized or brought the funding between school districts closer to equity than it had been before. No state ever got to perfect equity or really even close to it, but certainly there's been an impact in equalizing funding between school districts, mainly by raising the amount of state funding. Now, the third type of lawsuit, and the one I'm going to dwell on today, is the adequacy suit. Beginning around the late 80s, plaintiffs began to shift from equity to adequacy. And these suits are a completely different animal than the equity suits, because the equity suits sought to divide up more fairly the existing education pie. The adequacy suits, well, and for that reason they weren't popular among all school districts, because if you raise funding in some, you might lower it in others, and they weren't uniformly popular. But beginning around 1990, along came the adequacy suits, and they sought to expand the education pie. That is to get court orders requiring increases in state appropriations that poor and rich districts alike would share in. And needless to say, these were very popular among virtually all the educational establishment, or certainly most school districts. Now, there are few active desegregation cases in the federal courts today, and equity cases have more or less disappeared. Sometimes they're part of an adequacy case. But the real focus the last 20 years, I think, certainly the last 10, has been on adequacy. And I'm going to focus my remarks on adequacy today. These suits, as Bob said, have become so important that no course on school finance is really complete without covering them. But even though they've been filed and pursued in about 45 states, there's only a few states that haven't had them, they also fall below the radar screen of most people. But they should not, because once a court, a judge, has found a constitutional violation, the impact of that finding can be enormous, and it can last for years, even decades. In New Jersey, a school finance case started in 1969. It then morphed into a adequacy case. It was just dismissed last year, 2009. It was in the courts 40 years, and during that time it was the courts, not the legislature, which pretty much had to say as to how much money would be spent on education in New Jersey and what it would be spent on. So what exactly is an educational adequacy lawsuit? Well, every state has a provision in its constitution, I'll put some of them up here, that requires the state or the legislature to provide some sort of level of free education. And adequacy suits are based on the failure of the state to meet these requirements. Now, the fly in the ointment is that these provisions are very vague, and normally very vague. And they rarely define the education required with any specificity. I mean, you can see, look at this. In New York, all the Constitution says is you need a system of free common schools. A judge took that and decided that the schools needed to enable you to understand, among other things, complicated DNA evidence, etc. In Massachusetts, it's cherish the interests of literature and sciences. Now, these are all states where plaintiffs won cases. So these are in Arkansas. You can see the constitutional standard is that the state shall ever maintain a general, suitable, and efficient system of free public schools. Now, as a result of these, I think anybody would agree, pretty vague constitutional standards, the judges end up making decisions about education policy, education finance, such as what does it take to offer an adequate education? How much money should it cost? And in doing so, they end up, in effect, making the law. I think it's hard to argue that in New York, this judge wasn't making the law on what education required in New York. Now, as you might expect, this brings them into direct conflict with the legislature in most cases, which have traditionally, historically decided how to spend, how much money to spend, and what to spend it on. Typically, education budgets are a third to maybe even a half of the state budget. And so these are powers jealously guarded by the legislative and executive branches of government. I have to tell you, it doesn't make any difference whether the Republicans are in charge or the Democrats. They don't want to give up that power. And I've represented the state over my career. I've been hired by many more Democrats than Republicans. That may surprise some people. Now, because of this concern over separation of powers, a number of these suits have been dismissed at the outset because they involve political questions more appropriate for the elected or the representative branches of government than the judiciary. And in those states, the court simply decided that these provisions were too vague for a court to apply in the real world. The courts, in effect, would simply be substituting their judgment for that of the legislative bodies. But the courts in a number of states have reached, and let me just show you some of those. For example, in all of these states, they've been dismissed on separation of powers grounds. Florida probably has one of the strongest provisions in the country. It requires this, it's a paramount duty of the state to provide among other things, high quality education. Well, I'm a little wrong on that. That's an amended Constitution. The old Constitution didn't say that, but that state had its court case dismissed. But this isn't the end of the story, because a lot of courts have reasoned, well, wait a minute. It's our job to interpret the Constitution and determine whether a constitutional violation has occurred. In fact, if we didn't do it, we'd be violating our duty. That's what the Arkansas court in Lakeview found. It would be an abrogation of our duty not to take this case and see if there's a constitutional violation. And so, except for the cases that were dismissed on an initial motion on political question grounds, separation of powers grounds, from 1989 to 2005, a number of these cases went to trial, and the plaintiffs could hardly lose for a decade and a half. And these are just a list of cases that the plaintiffs won during that 15-year period. And many of these were very, very impressive victories. In New York, for example, the trial court ordered that annual spending in New York City be increased by 40%. A $5.6 billion increase. You know, I'd had a pretty good legal career until I lost that case. but $5.6 billion in one was the annual increase required. Now, the appellate courts wrote that down to $1.9 billion, but still, in most states and to most people, a substantial sum. Wyoming, I think, is the more interesting example. Their court order provided, the judge required the state to provide the, quote, best education. One, quote, visionary and unsurpassed, close quote. And they had to fund that above all other things. Well, the plaintiffs were lucky in Wyoming because they have a big mineral industry in that state that they can tax with impunity because those people don't vote, or they have very few votes. So they were one of the few states that's actually been able to come up with all the money that these costing out studies have required. And so spending in Massachusetts has gone off the charts. You can see where they were relative to the national average just before the court order and where they are now, which is about 60%, 70% over the national average. According to Ed Week, the last issue of Quality Counts in Education Week, they are the highest spending state in the country when you adjust for cost variations. So it's had a huge impact in many states. Kansas, Wyoming is one. Now, why were plaintiffs so successful during this period? Well, I think there were a number of reasons. And you won't find these in the court order, but just from looking at them, having been involved in a number of them, I think there were several reasons. First, there's no question that in many states, indeed probably all states, there are large numbers of children, often disadvantaged economically or otherwise, that are not performing up to snuff, that are not performing even at the basic level, whether you look at NAEP, whether you look at state tests or whatever. That's undoubtedly the driving force behind this. The moral legacy of Brown v. Board of Education, I can't emphasize this enough. Brown is the shining example in jurisprudence of the good that a court can do in undoing the wrongs of the past. And I think this inspired, even though these cases are decided on a completely different legal basis than Brown, Brown obviously inspired many judges who felt that they could do great things to solve a problem which this nation faces. So I think don't underestimate Brown. In fact, every brief I've ever seen in appellate by the plaintiff starts out by citing Brown. I think there was a development of legal rules that were very favorable to the plaintiffs in these cases. It almost became a matter of strict liability. If they could show that there was low performance among lots of children, which they can show in virtually every state, everything else is almost presumed, causation, etc., etc. And it was very, very difficult for a state to overcome these presumptions. I don't have time to go into all of that, but it's in the book. And like the issue of causation is an important issue in all legal cases, but it was not causation. It was almost assumed that the reasons for low performance was a lack of money. Now, ironically, plaintiffs were helped a lot by the advent of the standards movement. Because remember what I said about the constitutional provisions being very vague. Well, the judges like to attach or like to cite the standards as the legislature's interpretation about what the Constitution required. And of course there were tests that went along with it that showed many children were not meeting these standards. So the standards movement actually added a missing agreement, or it added it filled in a missing ingredient. Now, no matter that the people that adopted the standards movements weren't looking at the Constitution and saying, well, is this the constitutional standard or not? That never entered into the entry of the adoption of standards. But the court viewed them as one and the same. And then, of course, you had lots of experts with plausible sounding solutions. How can we solve this problem? I've got my program here. This will solve it. And in fact, we can even tell you how much money is needed. If you appropriate this much money, then you'll be achieving, or 90% of your students will be achieving at this level. And there were plenty of experts with plausible sounding solutions. And I think all of those reasons contributed to an era when, if it went to trial, plaintiffs could hardly lose. Now, this changed rather dramatically in 2005, and with key decisions in Texas and Massachusetts. And there, the plaintiffs had won at the trial courts, but the highest court of each case reversed those and dismissed the cases. Now, since then, there have been a whole string of cases. Some of them were the motions to dismiss I showed you earlier, but in Arizona, Texas, Alaska, South Carolina, Massachusetts, Louisiana, South Dakota, and Missouri, that the plaintiffs, or the defense, has won. And plaintiffs, well, I'll get to that in a second, but there's been a string of defense victories. Almost every decision has been either an outright dismissal of the case or a decision that was largely disappointing to the plaintiffs. For example, I list South Carolina here. Well, South Carolina court decided that grades K through 12 were adequate. There was enough money. It did decide that they need to look at pre-K. So it wasn't a complete state win, but obviously the plaintiffs were very disappointed with that decision. And a lot of these are just complete wins. Now, does this mean that that adequacy litigation is over, that this era is over? You know, it's hard to tell. Certainly, if you listen to the plaintiffs, it's a long way from over. And indeed, plaintiffs won a case just the other day in Washington State. There was a decision for the plaintiffs in that case, ruling that the finance system there did not comply with the Constitution. It's the first really big victory in 5 years, but and it's still at the trial court stage, but it was a victory. And not only that, there are new cases still being filed. There was a case filed just recently in Florida, which may have more, well, it doesn't have the most students in the United States, but it's one of the top 3, I think. There's rumors all the time about cases being prepared in Georgia, California, different states. So, but whether or not it's over or not, it's certainly clear that there's been a huge change in the way courts approach these. I think that the concept of strict liability has been replaced in many states with more of a deference to what the legislature has done, as long as it's not arbitrary. The standard is no longer, if it promises to improve the system, the state should pay for it. Courts seem to realize that any system can be improved and that should not be the basis for a constitutional violation for the courts intervening in the school system. I also think that this change in attitude has had something to do with the fact that these court-ordered funding mandates have not been the panacea that they were often promised to be in court. And with that, let me get to the main theme of this lecture. Excuse me. In discussing whether these suits have been a boon or a hindrance, one of the important aspects, obviously, is the intervention of courts into the traditional role of the legislature and the powers of the legislature. And that's very important, but I'm not going to cover that aspect today, simply because I don't have time. And besides that, the bottom line for many people is not whether the courts are stepping on the toes of the legislature. They want to know whether these suits are doing any good. Are they benefiting children or not? And so I'd like to confine my remarks to that issue. Now, I suspect if you ask most people this question, I've asked this question over the years, and the answers seem to fall into 2 categories. If you ask them whether adequacy lawsuits have been a boon or hindrance, you get one of these 2 answers 90% of the time. They're a boon. The court orders have provided strapped schools with much needed money. They're bad. money spent on all those lawyers could better be spent on the schools. And I guarantee you, those are the answers you're going to get. And those are the answers you're going to see in letters to the editor or whatever. Well, let's look into it a little deeper. First of all, we have the issue of resources. Now, this is what you see most often in the literature, that these cases have resulted in a lot more resources for schools in the states they've been brought. That's actually a more difficult question to answer than you think. There have been studies that have shown that they've resulted in increases in state funding, but at the same time, local districts have cut back on their funding. So the net effect has been no significant increase. Now that's across the country. That's the result of one study by some researchers. But there is no doubt that in some states they have resulted in significant increases of spending on education. And that's true in Wyoming, Kentucky, New Jersey, Massachusetts, Arkansas, I think. I'd put in that category, Kansas. But even if one assumes that they have increased spending on education, I think that still begs the question of whether they've improved the lot of children. In every adequacy lawsuit, the intended beneficiary are not the teachers, the vendors, the contractors, they are the children. And that's the ultimate, I've never seen a complaint yet that's based on helping teachers or contractors or school district vendors, except as a way to help children raise their achievement. For that reason, the key question in my mind is whether these suits have resulted in better student performance than might have been expected absent court intervention. Now, these court orders have been in effect in several states, in a number of states, for many, many years, over a decade, that have spent billions of dollars to implement them. And given the money spent, one might think that this issue has been studied to death by researchers, but it hasn't. There's very little on this subject. And there's almost no peer-reviewed research on whether these lawsuits have resulted in enhanced or improved performance by children. Much of what's been written has either been written by the promoters of the remedies or the supporters of the remedies, and that isn't very much. That simple fact in itself, I suggest, tells you that the news is not good, because these suits enjoy great support among most schools of education, and certainly in the media. And if there were good results, you would almost certainly see it published. There's no lack of outlets to publish good news about educational interventions. Now, when we wrote our book, Rick Hanushek and I wanted to answer the question in a way that we thought most people could readily understand. So we asked this question. We said, have students in states which implemented large-scale court-ordered funding increases for K-12 education significantly improved their performance relative to similarly situated students in other states during the period of the remedy? And we concentrate on the court order because most of these court orders, most of them focus on funding. And I'll get a little bit into that. So we wanted to see whether they've improved their lot relative to other states. And to answer this, we focused on the 4 states that have had large-scale remedies in place the longest: New Jersey, Wyoming, Kentucky, and Massachusetts. They both had these plans in effect for more than a decade. Plenty of time for any results, we thought, to show up. Now, as you can imagine, starting over a decade ago, we did not have consistent state test data over that period. So we couldn't use the state test. They changed. So were the ways they measured graduation rate. There'd been a lot of changes. But we were lucky enough to have NAEP scores from going back to the beginning of these remedies that we could then compare with the NAEP scores in the state, the most current NAEP scores, to see what had happened in those states. We did not want to look at simply whether the scores had increased, because they've increased in a lot of states. We wanted to see whether they'd increased relative to other states. That is, for example, if Kentucky increased its scores 6 points in 4th grade reading, and the nation increased its scores 12 points, we did not see that as a victory or a success for Kentucky's children, because they were falling further and further behind the national average. We also, unfortunately, going back that far, we did not have the scores broken down for between economically disadvantaged and non-economically disadvantaged children. But we did have separate scores for major ethnic groups, for white, black, Hispanic students. Now, and we thought it important to look at minority groups, because if the focus of these lawsuits are usually on poor and minority students, and if they weren't succeeding under the remedy, then we thought the remedy would have failed of its essential purposes. Now here's what we found. Now I should say these charts are not the same ones in the book. They've been updated to include the 2009 math scores. But I should also add that the adding of the 2009 scores has not changed the trends that we observed in our book. I'm not going to go through all 4 states, but let me go through a couple. This is Wyoming. Now, Wyoming is an especially good example because literally they got all the money they wanted. The legislature there was very, very generous. In fact, at the last accounting, they gave more money than the Picus and Auden costing out study had indicated was needed. So we thought this is one where it'd be interesting to see what happened in Wyoming. Well, here's what happened. You can see in the 4th grade. Wyoming 4th graders in reading started out above the national average in '92, which was about the time the lawsuit was filed. 2007, they were below the national average. This is white students, by the way, who are 90% of the population in Wyoming. In math, the kids started out at or maybe 1 point above the national average. By 2009, they're below the national average by 3 or 4 points. Same situation, 8th grade math. These are the only 3 scores we had that we could compare. They started out above the national average, and now they're below the national average. So for 90% of the children, they're further behind than they were when the lawsuit was filed. Well, let's look at Hispanics in Wyoming, the prevalent minority group. Even worse. The Hispanic students relative to the nation were performing above the national average when the remedy started. Now they're still performing above the national average, but not nearly as high as they were back in '92. Do I have a question? Or I'm going to take questions afterwards if you can wait.
Hispanics Hispanics across the nation, or all students?
Hispanics across the nation. Okay. Yeah. This is the average for Hispanics, not all students. Right. We thought by comparing groups we'd take some of the demographic changes out of the equation. So we're not comparing apples and oranges. We're comparing Hispanics with other Hispanic students in the country. Okay. Now, this is pretty clear trends, we think, but there's even clearer evidence in Wyoming. This is Wyoming expenditures versus its neighboring states, North Dakota, South Dakota, Montana, which demographically are almost identical. So you would think, but here's what they spend, according to the latest figures. These were in Ed Week just a month ago. Wyoming, on a cost-adjusted basis, spending over $16,000. The Dakotas are spending in the $10,000 to $11,000 range. Montana a little more. Wyoming is spending 40 to 60% more than its neighboring states. I don't have a chart on this, but it's in the book. I'll tell you that on every measure of academic achievement, save maybe one, Wyoming is behind these other 3 states. And not just behind, considerably behind. For example, on graduation rates, North Dakota's #1, Wyoming's 32nd, I think. And so this is an example of where the remedy doesn't appear to have done much. Now let's look at Kentucky. Kentucky has been lauded from the beginning as an example of what an adequacy suit can do. And undoubtedly it did a lot as far as reorganizing the departments and everything else. But let's look at student achievement. Well, here's the you can see in every situation, Kentucky black students, the principal minority group, were performing better relative to the nation in 1992 than they were in 2007 or 2009. In fact, in 4th grade and 8th grade math, they started out considerably above the national average and now are below the national average for black students. Let's look at white students in Kentucky. Okay, about the same. Maybe they've improved their standing in 4th grade reading a little bit. They've creeped a little closer to the national average, still far below it. About the same in math, both in the 4th and 8th grade. So maybe a little bit of improvement in the 4th grade reading in Kentucky, but still not anything that you could look at and say there's been significant success there. Now, I will tell you that the results in New Jersey are a little more complicated because it wasn't a statewide remedy there, but the results are similar. The remedy was directed at black and Hispanic students. Black students are doing about the same as they were in 1992 relative to the national average. Hispanic students are doing better in New Jersey. That was one of the bright spots we found. The main bright spot we found was in Massachusetts. Massachusetts was doing better. And the 2009 scores, incidentally, continue that trend. And they are the one state of the 4 we looked at where we could see significant improvement. I should add that the remedy, though, in Massachusetts was not simply funding increases. They did a lot in terms of enacting very strong standards, a very strong exit test for high schoolers. So there was a lot more about that remedy than there was in these other states, which were mainly focused on increasing funding. No, we did not include Arkansas in our analysis because the remedy here had not been in effect that long, and when we wrote the book. But I thought this audience might be curious about how Arkansas looked under this analysis. I was curious myself, so we did that, and I'm going to tell you what we found. Now, I got to add a caveat to that. I've not looked at anything further beyond these scores. And I'm going to show you this, and then there's a lot of people in this room that can take up this issue and look into it deeply. But I'm going to show you what I found. Okay. Now, the Lakeview View order, the final order, well, not the final order, these cases never have final orders, was issued in 2002. The remedy didn't start for a couple of years. I mean, the substantial increases didn't start. There was a $400 million increase, though, in the 2004-2005 school year. So we used the 2003 school year as our base. And we were also lucky enough, since we were starting much later, we did have the schools broken down, or we did have the scores broken down by the free lunch data. And we did have the 4th grade math score, too, so we had another score we could look at. So we decided to throw that in. Well, here's what we found. First of all, we looked at all students in Arkansas. This is what we found. In 4th grade reading, we found that Arkansas students had actually dropped a little bit relative to the national average. Not much, but a little. In math, well, in 4th grade reading, in 8th grade reading, they were identical. They'd stayed even with the national average. In a little below it, but still even. In 4th grade, in reading, however, I'm sorry, that was reading. In math, we did find some improvement. We found that both 4th and 8th graders were below the national average for all students, and that they were not yet at the national average, but they were getting closer. So, all students, seems to be some trend upward toward the national average. Good news, good news. But then I said, okay, let's look at this for the 60% of the students in the state who are on free and reduced lunch, the economically disadvantaged students, who are normally the focus of these remedies. It's not the middle class that's the focus of these remedies. It's the poor and minority children, usually. Well, it's a different picture. In reading, as you can see, the trend is bad. I mean, the 4th grade reading, economically disadvantaged students were above the national average. In the 4th grade, now they're below it. They were above it in the 8th grade, now they're at it. In math, they're about the same. I think the 4th grade math, they went from 1 point under to 1 point up, which, you know, that's a little bit of a change, but not much. And in 8th grade math, they're pretty much identical. So that's what the record shows. And if you look further at it, if you look at the non-free and reduced lunch program, they show some gains. So middle class children appear to be doing better, a little better. Poor children do not, at least based on these scores. Well, so what's gone wrong? Why haven't these lawsuits and the literally billions of dollars in additional funding that they brought to the schools had a more positive effect? Now, if I could answer that question definitively, I'd be like the Waltons. I'd be a billionaire. But no one can answer that question for sure, but I'm going to suggest some things to think about. One problem with the court orders, I think, is they have worked to strengthen the status quo and not to change it. These court orders have almost always focused on increasing spending and little else. They order more spending, but they've almost in all cases left the educational establishment free to spend it as they always have. And in fact, I think that's been borne out by reports in Wyoming, even here in Kentucky. So for that reason, the status quo is continuing. You know, when I think about this, for years, the legislatures have come under incredible criticism for not spending enough money on education. But this is a solution to most courts. But actually, when you look at it, spending in the United States on education has increased at a rate far above inflation. And this chart shows that. This is from 1960 to 2005, and this is cost-adjusted dollars. It shows that spending back in 1960 was on a, well, actually the actual spending was $375 a student. If you adjust that for inflation, it was $2,606. Now it's almost $10,000, almost 4 times as much. And yet, I'm sure you've seen these before, but yet on the long-term NAEP trends, there's been hardly no change in academic performance. The reading scores are flat. The mathematics scores, for all practical purposes, are flat. That difference from 304 to 306 is not statistically significant. And science scores have actually come down 10 points. So, you know, one of the points we make in our book is that, ironically, I think one of the few things legislatures, at least across the country, have done, not in every state, that's the one function they perform very well. What function they've not performed is coming up with different, more unique or more innovative ways of improving education. But that's not what's attacked in these school cases, it's the funding. Another reason I think that these court cases have had problems is the courts almost uniformly have refused to address other possible problems of poor achievement. They don't even address them. I mean, for example, teacher compensation systems. I think it's pretty well known among researchers that most teachers are paid based on experience and on education degrees, but at the same time the research says that, except maybe for the first few years of experience, those factors don't bear any relationship, significant relationship to student success in bringing about increased student achievement. You won't find a word in any of these about maybe changing the way we pay teachers. You won't find a word about union work rules. In New York City, the teacher was barred from teaching students more than 3 hours and 45 minutes a day by the union contract. You won't find a word about that. tenure rules which make it almost impossible in some places to fire incompetent teachers. Not a word. Waste and inefficiency in local operation, not a word. Courts handle that in one or two lines. They say, well, the state can change that, they're in charge. If that's a problem, fix it. Of course, that ignores all the practicalities of how the state reaches down into local districts to fix those problems. So those problems are rarely, if ever, addressed in a court order. Now, why you say, well, why can't the legislature still take that up? Well, the legislature is faced with a court order requiring more money. They've got enough on their plate. And there's nothing in the court order to show them that says, wait, the court also says that these union work rules are having a huge impact. There's never anything in the court order about that you can show the legislature. And most important, I think, alternative means of education reform end up on the back burner in the states with these court orders. During the legal proceedings, there's a structural, practical reason for that. First of all, the plaintiffs are always seeking more money. That's the main remedy they seek. At the same time, any third party that wants to intervene and say, well, maybe instead of doing this, we ought to have more choice, or we ought to change the way teachers are paid, or we ought to have more charter schools, they're almost uniformly rejected by the courts. When I say rejected, I don't mean their arguments are rejected. I mean they're not even allowed to go into court. Their motions to intervene are denied. Well, you can ask, well, why doesn't the state's lawyer make these arguments? Well, it's really impossible for the state attorney general or lawyers such as myself to make an argument that what the state needs is more choice when that whole issue hasn't been vetted through the legislative process. Because there's a legislature sitting up there and saying, well, wait a minute, who's this guy to be saying we ought to have choice? So my point is, it always boils down to a question of money, with the plaintiffs arguing it ought to be more, the state arguing it ought to be less. That always ends up being the issue in these remedy hearings. Now, there may be some window dressing on it of other things, but that's mainly what it boils down to. Now, once the court sends the case back to the legislature, you might say, well, then the legislature can take it up. And these other people are free to come in. Well, by then, there's a court order that, for example, in New York said increase funding by $5.6 billion a year for New York City. Well, I got to tell you, the legislatures there had all they could do to figure out where to come up with all that money. They didn't have time to be considering whether we ought to have more charter schools or whatever. So these other reforms get pushed toward the back burner. And so in that sense, I think these suits have had a very not a beneficial effect on other types of reform. Well, let me wrap up this by saying, you probably already surmised this, but I think these cases have been more of a boon than, more of a hindrance than a boon to education reform. There's no real significant evidence that they've resulted in meaningful performance in children, and that's particularly true among poor and minority children. And worse yet, I think they've served to strengthen the status quo while discouraging other types of more fundamental reforms that might hold out more promise, such as expanded choice, better ways of paying teachers, other changes. In fact, we devote a whole chapter in our book to some other things that might be done. It's incumbent upon the country to find more effective reforms that actually improve student achievement. We don't want to wake up 40 years from now and discover that we're still at the same point. Well, that's what we're doing. We're 40 years from 1960 and or from 1970, and we're about at the same point. Now, I don't want to end on the down news. Actually, I think at this point in time the news is not all that bad. And what I mean by that is I think the time is more ripe now for meaningful education reform than it has been for years. And why do I say that? Well, there's a couple of reasons. First of all, as I said earlier, these court orders are no longer as dominant in the legislatures as they were even 5 years ago. They are in some states, but in many states they've been dismissed. They're no longer taking up, literally sucking the wind out of the legislature. And so the legislatures are free to consider other types of reform. I think we're obviously in an era where states face severe fiscal constraints. And the solution of increasing spending may not be a viable solution anymore. So we have to look for other ways to help children improve their performance. So I think that's a development. That's certainly, most school districts probably don't view that as a good development. But I think as far as pushing reform, it might help actually. And finally, I think we're seeing some leadership at the top. President Obama's administration is supporting more innovative approaches and is pushing some money in that direction. One of the things I admired about him is during his run, he stood up before the NEA, the most powerful union, not teachers union in the country, and advocated merit pay for teachers. That took a lot of guts. So we'll see what's going to happen. But I think the time is right for more, and what I mean by true reform is reform that helps children and results in improved achievement. I'm going to end on this note. This is obviously a very complicated subject. I've only touched on it. If you'd like to read more, I'll put in a shameful plug for my book, or Rick and mine's book. And I want to thank you again for inviting me, and I'd now be happy to answer any questions. Anybody have any questions? Bob?
It's a really good book. When will the paperback be out?
I'm not sure. Actually, we have one paperback version. It was a special printing for a group, but I don't have any information on that.
Well, let me ask the question. If we look at
I had to pay him for that.
Look at the adequacy lawsuits. That, like you said, the breakthrough is in 2005, but before the plaintiffs won, afterwards the defendants won, pretty much. It struck me that within that too there was some variability, and I'm wondering, and you would probably code this in the data. You said in there's no tendency for judges to really consider what the state constitution says when they rule on these things. Can we code something like where the judge lives, background, that sort of thing, and see if that would have some explanatory power? Because that'd be a fun little article.
I think some people have actually done that. They've looked into judges' prejudice to see whether that's, or preferences, prejudice, whatever you want to call it, to see if that has some influence. And I think they concluded it might. But it varies from state to state. I mean, if you're defending the state, you probably don't want a former legal aid lawyer as the judge. Mm-hmm. If you're a judge may want to write a landmark opinion. I didn't include that as among the figures, but obviously that can be pretty important when you draw. In fact, we've seen cases, I'll give you an example. In Georgia, there was a case filed, and it went on for 2 years and was just about ready to go to trial. And the judge who was going to try it was probably left of center, I would say. Not real liberal, but probably left of center. But she was a good judge, and we were both satisfied with her. Well, about a month before the trial, she got, for reasons related to the state's fiscal situation, her position got abolished, and she was a special. And anyway, a new judge was just selected at random, but he turned out to be a Republican appointee, fairly conservative. They dismissed their case. They obviously did not think they could get a fair trial before this judge, who, as far as I know, was a fair individual, but his political leanings were pretty clear, so they dismissed their case. So does that have an impact? Sure, it does. And it's hard to explain the pattern of these cases. If you look at the 5 highest spending states in the country on education, every one of them has been found liable in a school finance case, in an adequacy case. In New York, Massachusetts, let's see, Vermont, Connecticut, I forget which the other one. They've all been, or New Jersey, they've all been held liable. If you look at the 5 lowest spending states, none of them have been held liable. So go figure.
I just have a question. I don't have a better answer for it, but I'm nervous about the comparison of the states in which we had lawsuits to the ones in which we didn't, because that assumes that these are the counterfactual. What if there were no lawsuits?
Mm-hmm.
One might presume that maybe these other states spent more because of the context. We viewed lawsuits as kind of a national reform, where we better spend more, or we may get sued, or we better spend more, or we may lose a suit. And I'm not sure how I would put that into the analysis, but have you thought about that? Have you ever talked about that as a problem?
A little bit. I guess part of the reason we selected the 4 states we did is because they were such obvious examples of big, huge increases. Massachusetts' budget went from $3 to $10 billion in 10 years. Wyoming, as we said, went way up. New Jersey is out of sight. And it only applies to the 30 so-called Abbott districts. But they spend, the richest district, they spend $3,000 or $4,000 a student more than the richest districts in the state. And so we thought those were pretty good examples.